So I understand from the presentations today about arbitration. I've been informed that except for fraud of the arbitrator or some fraud involved in it, arbitrations are binding by the parties. Contract, they've agreed to it. People make mistakes. It's like a mistake. What happens, is this a balance of the benefit of avoiding the litigation, the speed of arbitration, lower cost, applying laws we understand? Are we accepting mistakes in the arbitration?
So successful arbitration tribunals must have an internal appeals process. If you don't have a strong enough internal appeals process, one day you make the kind of boo-boo that the secular judge looks at and says, this arbitration process is incoherent because you made the kind of egregious mistake that everybody makes on occasion, but which would void the arbitration. You describe a piece of property incorrectly. You make a mathematical error. I've been involved in an arbitration where the arbitrator wrote down the numbers wrong and he closed the hearing 2 days before one side submitted. So people make mistakes. Error is error. You have to have an error correcting process internally if you're going to be affirmed on appeal.
Or New York picks that up externally, where you've got, after an award is issued, you've got 90 days to move to modify or vacate the award. And I think there's also and then you can do a court to do that, or you've also got the ability to go back to the arbitrator and say, look, you misdescribed the property, or you added 2 + 2 and came to 3. Can you please fix the face of the award?
But other than simple or more mistakes, blatant of this, what happens if the arbitration decides to apply French law? All the procedures are correct. Everything is done in accordance with due process, and the arbitrator misapplied French law.
So it's hard to appeal substantively.
Yeah, but there are many examples that run through many jurisdictions where they say, well, the arbitrator isn't bound to apply the law. The arbitrator can throw it out of the window, choose something else, can ignore the law, can run contrary to the law.
But even when the arbitrator just makes a boo-boo, because boo-booing is life, meaning when you say that you're going to hear 100 cases and you're going to get the law 100% right 100% of the time, I don't want to be in that business. Because to boo-boo is to err. Boo-boo is life. People make boo-boos.
Yeah, and just
Because it's also worth remembering in a court situation, you can't necessarily appeal every mistake made by a judge or a jury. What is an appellate, grounds for appeal is constrained as well.
So when one chooses arbitration, one acknowledges that arbitration is an arbitrary judge.
Not arbitrary.
As he decides,
He's
that
human.
decision is final.
He's human.
And one accepts
Some
that
of them.
mistake.
But I don't know if that's any different than a district court judge. You think the district court judges aren't human?
no.
But there's an appeal from that.
No,
Okay.
but there are. But many times the appellate court, and run through appellate courts all the way up to the top, many times the appellate court judges will say, yes, but it really didn't impact. There is an institutional protection that you'll appreciate that runs down the line. One thing that I found very refreshing with the Becton of America is the fact they publish quite a few of their decisions. Now, okay, they changed the names. The change of the names is very interesting because they always give them like very Jewish names, like it's Chaime Mendelssohn versus Chaime Torres. But then you can start to see the way in which an institutional arbitration body like the Becton of America has a way of deciding that there is a pattern that runs through, whereas with the AAA or somewhere like that, where they don't publish their awards, even with the change names and the anonymity provisions, you really are stepping sometimes into the total unknown when you're choosing who your arbitrator is.
Thank you.
Please.
What recourse or remedy does an individual have where after a decision is handed down by an arbiter, one party says, I'm not going to comply.
The party that wins goes into court
And then it becomes...
and seeks enforcement of the award. The party who wins goes into secular court and seeks enforcement of the award. A secular judge reviews the arbitration not to determine if it's correct. He only determines if the arbitration contract was properly entered into and whether the arbitrator's award was without what we'll call in the big picture fraud. And then the judge does not get to look at the arbitrator's award to determine if that's the decision he or she, as the judge, would have issued. There's no such review. It's very limited.
And then it becomes a judgment. And then it becomes a judgment. It's confirmed as a judgment like any other. Now, there are plenty of litigants in court who refuse to abide by judgments. The enforcement mechanisms are exactly the same thereafter.
Of course, it's an interesting question exactly how much oversight the civil courts will apply. So if you remember back to what I call a purely ecclesiastical adjudications, like the Methodist minister who was challenged because he performed a same-sex marriage. What's interesting is that with respect to those, sort of traditionally purely ecclesiastical sorts of decisions, the courts aren't even going to look into claims of fraud, right? They're not going to look into procedural due process. They're not going to look into all of those sets of issues. So it becomes a sort of interesting question why, with respect to those sorts of adjudications, they defer essentially absolutely, as long as it's within that subject matter. And with respect to all these other areas in which religious tribunals play a role, there's a tendency, at least to some extent, to treat them like other forms of arbitration. And you can imagine a case, right, where a religious tribunal will say, well, you know what, our religion actually doesn't allow for 7 days notice, right? And on the fly, I can't quite sort of conceive of why religion would say that, but,
I could imagine a
as
religion...
Michael points out, religions are weird. All religions are weird.
But I could imagine a religion which says this proceeding has to be conducted in Hebrew, and if you don't understand Hebrew, tough. And secular law says you may not conduct a hearing in a language that the parties don't understand. I could give you, that's an example of a procedural conflict that I've thought about and that you sometimes even encounter, where you have a clear religious mandate to conduct something in a language, but they're mostly deeply religious. And in a deeply religious setting, there's much less judicial review.
I was thinking more in terms of civil disputes that...
It's hard to construct a conflict. A religion that's not prepared to modify its procedural rules to accommodate the procedural rules of the United States gets kicked repeatedly by the secular courts, and then they get out of this business.
I just want to address one quick question to Professor Dane. You presented a couple of different models for how these arbitration panels or alternative courts might operate in the American context. One of them being this private ordering system, the other being a kind of legal pluralism. How do these various models shape the range of outcomes and maybe the interaction between the range of outcomes within those two systems? Yeah, that's right. So, Professor Broyd suggested that one of the most important things about these alternative dispute resolution systems is that they reduce uncertainty. Right? If you have no idea how your case is going to be adjudicated, you're simply not going to use them. Right? So, does the legal pluralism model, because perhaps the various entities are reading each other's rulings, right? And might have an access to broader range of laws, right? Does the legal pluralistic system reduce some of the uncertainty,
Well,
as opposed to the private ordering system where we're not really sure?
right.
What's-
So when I contrasted those two models, I suggested that these are different ways to think about these various tribunals, and different ways that we as a larger society might or might not justify them. But I think the issue you're bringing up also suggests that they reflect different ways that the individuals involved might want to participate in these sorts of tribunals. So, from that private ordering perspective, the reason to go into arbitration is exactly the one that people have emphasized. It's quicker, it's cheaper, and it's either more certain, right, or at least certain enough given the advantages in cost and speed. I mean, you might be willing to give up a certain degree of certainty because of these other things. But I suspect that people will often go and commit themselves in advance to religious tribunals, not merely because of cost uncertainty, and not even necessarily primarily because of cost uncertainty, but because of ideological commitment. And at that point, the certainty might simply not be a major issue for them. I mean, they want to have some certainty that it will be the religious community that will be judging them. But they might well be less concerned about the certainty of outcome or the predictability of outcome. And here's actually where the Christian case becomes very interesting, because Jews and Muslims are very used to this notion of religious law as an all-encompassing system. And Christianity for 2,000 years has to a large extent, with various meanderings and challenges along the way, Christianity for 2,000 years has to a large extent defined itself as not being a legal system, right? As being something other than a religious legal system. That's not to say that there isn't religious law, not to say that there isn't canon law, but it doesn't play nearly the same sort of central role. So it's easy to imagine Christians in particular going and that's why a lot of these new Christian tribunals style themselves very much in terms of conciliation, right? Because the point is, to some extent, to not merely to find an alternative law, but to escape law, right? To escape law in favor of reconciliation, to escape law in favor of mediation. And at that point, you might be willing to give up a good deal of certainty precisely because of the ideological commitment to that type of form. The other interesting thing about Christianity is, precisely because Christianity typically doesn't think of itself as a religious legal system, many Christians actually have an ideological commitment to the state's legal system, which is why, with respect to marriage, for example, lots of people with the same-sex marriage debate have said, well, why not just eliminate this, why not just eliminate the state's role in marriage entirely? Make marriage entirely a religious matter. That sort of that works pretty well for Jews and Muslims. It works halfway for Catholics. Catholics are a sort of interesting case. From the point of view of traditional, and I'm not talking about some sort of the new reactions, but from the point of view of traditional mainstream Protestant theology, marriage is a state institution with religious significance, right? There's no such thing as a religious law of marriage. There are religious constraints on what they think the state can do, like the question about same-sex marriage. So from a sort of traditional Protestant theological point of view, it simply wouldn't make sense to offload everything to the... Now, it doesn't mean that it couldn't happen. Theologies could change. But it would be a tough slog in a way that it wouldn't be for Jews and Muslims and would be sort of halfway for Catholics. So the exact nature of the relationship between these various communities can get very complicated.
I just want to touch on a very quick point there. We're talking about certainty versus. One of the main ideological drives of some people is the right, or they feel they have a right to be understood. A right to be understood by their tribunal. And that comes, the interplay between the litigant and their tribunal, credibility and trust in that tribunal is very important. And the build of that trust en route. So some people may give up legal certainty for the understanding or for the appreciation that their tribunal will understand exactly what they're talking about. So when you can have, in the Bet Din of America, for example, an IP practitioner brought in who doesn't need to be told about the concept of an intangible or the concept of a conceptual when understanding trade secrets, for example, or a patent dispute, that even if adverse findings are made, the person feels like they've been understood. And it kind of segues into what this gentleman was saying there regarding people understanding the particular issues that they are dealing with and not dealing with it higher up on a broad brush level. And that's why people may give up legal certainty, for example.
Thank you very much. Let's thank all of our panelists.
I enjoyed it very much. It's very complex.